This case starts off looking like a routine bond reduction hearing. What unfolds here is a complex story involving a firearm, a violent confrontation, and a defendant trying to convince the court he deserves a second chance. With a pregnant fiancée, no financial resources, and serious charges on the table, the stakes couldn't be higher. The real question is, was this a moment of fear? Or a dangerous pattern of behavior? Stay locked in, because this courtroom is about to reveal everything piece by piece.
All right, and this is Rakeem Asmore?
Yes.
How do you pronounce your last name?
Asmore.
Asmore, okay. All right, so you're here asking for a bond reduction?
That's correct, Judge.
All right, court is calling 2024 CR 008783, State of Texas versus Rakeem Asmore. Can I have parties announced for the record for the state? Defense?
Joanne Akel.
And are you Mr. Asmore?
Yes, ma'am.
All right, defense has filed a motion seeking a bond reduction. State, have you had a chance to review the motion? All right, is there a proposed agreement or no?
There's no agreement.
All right, defense?
Judge, I'd like to call a witness, please.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, and if you could stop moving, it's making me a little bit nauseous with the camera movement. All right, if you'll state your name for the record.
Deja Young.
All right, and to the court reporter, that is Deja, last name Young. Any objections to this witness appearing by Zoom, state? And defense, I'm assuming you have no objection?
I have no objection, Judge.
And Mr. Ashmore, you have no objection to this witness appearing by Zoom?
No, no objection.
All right, defense, you may proceed.
Thank you. Ms. Young, can you tell the court what your relationship is to Mr. Asmore, please?
Fiance.
And are you aware of the amount of the bond that is currently set for Mr. Asmore today?
Yes.
Okay, and how much is that?
100,000.
And are you currently expecting Mr. Asmore's child?
Yes.
Is that one of the reasons why you could not appear in person today?
Yes.
And when is your due date?
October 3rd.
All right. Are you aware of Mr. Asmore's financial condition?
Yes.
Does he have any bank accounts?
No.
Does he have any assets he can sell to raise money to make this bond?
No.
He doesn't own any real estate that he could sell or mortgage?
No.
Does he have the ability to go to any banks to borrow any money?
No.
And you were wishing to assist him with raising money, is that correct?
Yes.
Do you have any bank accounts?
Yes, but nothing.
Is there any money in your bank accounts?
No.
All right. Do you have any assets that you can sell or to raise money for this bond?
No.
Do you have the ability to go to any bank to borrow any money?
No.
Have you attempted to raise money from family and friends?
Yes.
What's the total amount of money that's the family and friends have been able to raise?
250.
All right, I'm sorry to interrupt. When you say 250, what do you mean?
Is that dollars or what?
Yes.
$250? All right. Are you asking the court based on Mr. Asmore's financial condition to reduce his bond today?
Yes.
All right, I'll pass the witness, Judge.
Ms. Young, are you aware of the offense that Mr. Ashmore is facing?
Maybe she can.
Ms. Young,
Yes.
are you aware of the offense that he's currently facing?
Yes.
You aware that this is regarding a firearm?
Yes.
You aware that he discharged the firearm and injured someone else?
Yes.
And you would agree with me that anyone who discharges a firearm and hurts somebody is a danger to the community, correct?
Yes.
No further questions.
Well, I will tell you, to be on the safe side, if I grant his bond reduction, I am going to ask for a referral to Center for Healthcare Services and they can do a thorough evaluation because I don't want him to have issues and then I didn't address them. All right, so we're back on the record and 2024 CR 008783. Any other evidence, counsel?
Nothing. Oh, well, I guess just for the court's edification, my client resides with his mother, not with Miss Young.
Okay. All right.
Right away, the defense is building a sympathy angle highlighting financial hardship and family responsibility. A pregnant fiancé, no assets, and only $250 raised. That's a powerful emotional setup. But here's the legal reality. Bond isn't lowered just because someone can't afford it. The court has to balance financial ability with public safety. So the real question becomes, does his situation justify a lower bond? Or does the alleged crime outweigh everything else?
And I'm sorry, one final question, sir. Have you ever used any type of drugs in the past?
Yes, ma'am.
And what would that be?
Cocaine.
Okay. All right. Any other witnesses?
No other witnesses, Judge.
State, any witnesses?
No, it is.
All right, the court will hear argument. Defense is your motion. You may proceed.
Thank you, Judge. As the court's aware, and the court has heard testimony that $100,000 bond is way over the financial ability of my client or any of his family members to make. A bond should not be used as a method to maintain somebody in jail. Its sole purpose is to ensure that they would appear for court. I would ask the court to consider reducing Mr. Asmore's bond. Adding any other conditions the courts feels necessary to ensure his appearance.
All right, state.
Judge, we asked the court to deny the motion. This is an aggravated assault with deadly weapon. There was a firearm that was used. There was injury that was caused to the complainant. We believe 100,000 is reasonable under the facts of this case. However, if the court were to reduce the bond, we ask that the court not reduce it no more than 75,000 and to keep the special conditions in place, which are the full house arrest, GPS. We don't have any objection to the fees are waived, the no contact orders with the complainants, and the firearm prohibition.
All right, this is what the court is going to do. The court will set your bond at $75,000. There's to be no contact with the complainants. Of course, no possession of firearms. If your mother has firearms in her home, they need to be removed. You understand?
Yes, ma'am.
There's going to be full GPS, waive fees, and you to reside with your mother at the address that's previously been stated. There's to be a referral to Center for Healthcare Services, and there's to be regular random UAs, waive fees. Is there anything else?
Nothing's actually.
All right, when is this set on the docket?
It has no setting, Judge. It was just indicted.
All right, Ms. Ferguson, let's give this a setting in 30 days. All right, and make sure that he receives a reset form. All right, is there anything else?
Nothing, Your Honor.
All right, thank you. And are you, Mr. Astral?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Ashmore, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes,
Did you
ma'am.
understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment? I do. State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are going to proceed on count 1 and waive count 2.
Any objection?
No objection.
All right, did you review the document entitled Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That is a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court.
And this is where the tone shifts completely. The prosecution cuts straight to the heart of the issue. This isn't just about money anymore. A firearm was discharged and someone got hurt. That instantly raises the stakes to community safety. Notice how the witness is forced to agree that this kind of behavior is dangerous. That's a key moment. It reinforces the prosecution's narrative. Regardless of personal struggles, actions like this carry serious consequences.
Does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Ashmore, has anyone threatened, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count one. Punishment is to be assessed at a cap of 12 years in the prison. There's a $1,500 fine. State is opposed to your applications. There's an affirmative finding of family violence and there's been no contact with it. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of your plea? Did you understand that to be your plea bargain agreement?
Yes, ma'am.
All right, defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor. The only thing is, we also did check affirmative finding a deadly weapon. I just wanted to
Oh,
make
I'm
sure
so
that was
sorry.
correct.
Thank you.
Yes,
And there's also an affirmative finding of deadly weapon. Did you understand that?
Yes, ma'am.
All right. Did you review the document entitled waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that are filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Then to count one, how do you plead guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
State offering states one in all attachments.
Objection, Judge.
And state, have you spoken to the complainant?
Yes, Your Honor.
All right, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments and review the same. All right, after reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find him guilty. Court will defer finding him guilty as you've applied for deferred adjudication. We can go off the record. Counsel, if you want, we can set it for a PSI. It'll be about 8 weeks. Or if you would like, we can recall it sooner. And I will hear whatever witnesses you would like to bring. And I would ask the state for his criminal history.
Judge, I think I need a PSI.
All right, Ms. Ferguson, I need a PSI and a TAP evaluation. All right, May 5th.
Judge, we have one issue.
Mhm.
I'm assuming because of this thing, my client comes off GPS today.
No.
All right, I filed a motion for the court to
So the judge makes a partial move reducing the bond, but not dramatically. Dropping it from $100,000 to $75,000 shows the court is acknowledging financial limitations, but not ignoring the severity of the charges. And look at the conditions: GPS monitoring, no firearms, no contact orders. These aren't light restrictions. This tells you the judge is trying to strike a balance. Give the defendant a chance, but keep tight control over any potential risk.
consider allowing my client to work while he's on the GPS.
All right, any objections to allowing him to work?
Yes, Your Honor, only because of the facts of the cases the court has just read in the stipulations. Additionally, we did speak with the complainant and she does have safety concerns. Those would be the two objections from the state.
All right, this is what I'll do. We'll come back with regards to the hearing on the GPS, and what I'm gonna need is proof that he's employed and what his work schedule is.
I have that today, Judge. Well, at least I have the hours that he works and where he's working
From the company?
from the company. Well, me better,
Okay.
but I do have it.
And
How soon, Judge? Because I've been trying to get this since last.
Oh, just speak to Ms. Ferguson.
Okay,
We'll put it down.
thank you.
All right, the court is calling 2024 CR 008783, State versus Rakeem Asmore. Could I have parties announced?
Ashley Jones from the state.
Joanne Akel from Mr. Asmore.
And are you Mr. Asmore?
Yes, Your Honor.
All right, you entered a plea of no contest to count 1 on March 4th. According to your plea bargain agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $1,500 fine. Affirmative finding of deadly weapon, and the state opposes your application. There was a PSI and a TAP evaluation completed. Have both parties had a chance to review the PSI and TAP evaluation?
Yes.
Yes, Judge.
Any objections?
Judge, I don't have an objection. I do have a correction.
Yes.
Okay, in the evaluation, it indicates that my client is unemployed. He is currently employed
Mhm.
by Burger King.
Okay.
So we would just request that change.
All right. Any witnesses, state,
Not from the state, Your Honor.
defense, any witnesses?
Yes, I have 4 witnesses.
All right, call your first witness.
Okay, I think they're waiting outside.
All right, could you raise your right hand for me, please, sir? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand if you'll state your name for the record.
Robert Daniel McDonald,
All right, defense, you may proceed.
Thank you, Judge. And how are you employed?
police officer with the San Antonio Police Department,
And how long have you been so employed?
24 years.
I'm going to ask you to reflect back to April of 2022 and ask you if you were called out for service for a terroristic threat.
Yes,
Okay, I know that's been a long time. Would it help you if I hand you your police report so
Yes,
you can
please.
refresh your memory? Well, he's refreshing.
Oh, no. it's-
Okay, can you tell me where you were called out to, Officer McDonald?
the address is 7313 San Pedro Avenue.
And was that at Jimmy John's?
Yes,
And when you made this call, you were there to investigate a terroristic threat?
yes,
Okay, what was the nature of the threat? Was a person threatening to shoot up the Jimmy John's?
Objection to hearsay, Your Honor.
All right, that'll be overruled.
You can answer that question.
yes,
And were you, as part of your investigation, did you discover that Rakeem Asmore worked at the Jimmy John's?
yes,
And the person that was making, as part of your investigation, the person making the threat, was that Ashley Williams?
Objection to hearsay, Your Honor.
Overruled.
yes,
And did you also discover that Ashley Williams was in some sort of relationship with Rakeem Asmore?
Objection to hearsay, Your Honor.
All right, that'll be overruled. And let me just tell you, I understand where you're going with this. So this is
Now we enter one of the most critical phases of plea. The judge is laying out the full weight of what's at stake, up to 20 years in prison. This isn't just paperwork. This is where the defendant gives up fundamental rights, including a jury trial. A lot of people don't realize how serious this moment is. By accepting these terms, he's essentially putting his fate directly in the judge's hands. So ask yourself, would you take that risk?
what I need to know. So with regards to this report, that there was a terroristic threat, who is the person who was calling in this report that there was a terroristic threat?
Not the defendant.
So it wasn't the defendant who called it in.
His employer.
So his employer called it in. All right. So I understand, and I want everybody to know this. I understand the rules of evidence and what's going on, but I'm trying to make a clear decision on whether or not he should be going to prison or whether or not I should give him deferred adjudication. So it appears where this testimony is going is that there was a previous terroristic threat involving the complainant of this instant case. Am I correct?
Correct, Judge.
All right, you may continue.
And those are, I'll pass the witness.
Officer McDonald, you responded that day?
Yes.
So the store owner told you that the defendant told the store owner that the victim was making some threats, is that correct?
I believe so.
Okay. And to your knowledge, were there any actual charges filed with our office for that case?
I don't know. No idea.
No further questions, Your Honor.
Okay, isn't it correct, Officer McDonald, that the person that actually told you about the threats was the employer of Jimmy John's? E1?
Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Deja Young.
All right, you may proceed.
And Ms. Young, can you tell the judge what your relationship is with Rakeem Asmore?
I'm his fiance.
And you probably need to speak up so the court can hear you.
I'm his fiance.
And do you have any children?
Yes.
How many children do you have?
Well, 2 and 1.
Okay, and are those children, is Rakeem Asmore their father
Yes.
for both of the children?
My oldest, no, but he's raised her since she was 2 months.
And how old are your children?
19 months and 6 going on 7 this week.
And you're pregnant with your third child
Yes,
and also Rakeem's child.
yes,
Okay, and are you aware of the reasons why we're in court today?
yes.
And how long, can you tell the court, how long have you known Rakeem Asmore?
It's 2017.
Can you give some idea of the kind of person you believe that you have known Rakeem Asmore to be?
My perfect guy, I don't know about anybody else, but he's since, I had a situation going on. He's been there for me, even when back in high school. We just kind of were not able to be together at that time because we were just kids, but honestly, I'd say he's a good man to me.
He's been a good man to you and to your
Yes.
children?
For my children, it's definitely a great father.
Have you ever known Rakeem to be a violent person?
No.
Okay. Do you know anything about Rakeem's relationship with Ashley Williams?
Just everything I've heard.
Now, I like to make a decision because y'all are coming to me whether or not to send him to prison or whether or not to give him probation. This is what I need to know. And state, maybe you know that this answer. I don't know. Is there evidence out there that the complainant previously tried to run him over, previously committed terroristic threat? I can understand why it's not a self-defense issue that's going on here. But is that true? Does anybody know the answer to that?
2 years before this incident,
Mhm.
there were 2 reports, one a terroristic threat from Jimmy John's, as the court has heard, and the other a hit and run, as the court has heard. The suspects in those cases were the complainant, were the complainant in this case. However, no charges were ever brought from either of those police reports.
Okay. All righty. We're back on the record. Let's continue.
Thank you, Judge.
Sure.
I call Rakeem Asmore.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Rakeem Asmore.
All right, you may proceed.
Okay, Rakeem, are you working?
Yes, ma'am. I am manager
Where do you work?
at Burger King.
And how long have you been working there?
Before I was incarcerated, I was there for 10 months, going on 10 months now.
All right, and how long were you incarcerated?
9 months.
And when were released?
I was released, February, I want to say 26.
Of this year?
Yes, ma'am.
Okay, and do you have any children?
Yes, ma'am.
How many?
I have one stepchild, a 19-month-old. I have a biological one, 6 months, and I have one on the way. So 2 children.
All right, are you currently involved in taking classes to help you with your rehabilitation?
Yes, ma'am, I have.
Okay, have you completed some of those classes?
I completed my anger management. I completed my gun safety. I completed my parenting. I'm currently enrolled in bid family violence class, and I'm gonna start taking. Forgot the name of the other class I'm going to take.
Is it the moral recognition therapy?
Yes, ma'am.
All right, did you receive certificates for your anger management class, your gun safety class, and your parenting class?
Yes, ma'am, I have.
All right, and do you have those certificates with you today?
Yes, ma'am, I do.
All right. And Judge, we have these certificates for those classes if the board wants to look at them. Here. Thank you, Judge. Can you just tell the judge briefly what happened the day this incident occurred? What started this incident?
This is a huge turning point. The judge is openly questioning gaps in the case, missing evidence, unclear details, and prior incidents that weren't fully explored. That's rare and extremely important. It shows the court isn't just passively accepting what's presented, but actively digging deeper. And here's the twist. If there really were prior threats or a car incident, it could shift how this entire case is viewed. Suddenly, this isn't just about one moment, it's about context.
I was just getting off work, ma'am. I stopped by the store to get cigars. I ran into my ex-girlfriend. I ended up leaving. She rammed the back of my car. She had took off, and I had
Hold on, let
got,
me stop you there. She rammed the back of your car?
yes, ma'am, she smashed the back of my vehicle.
Okay. Were you afraid when this occurred?
Yes, ma'am, I was.
Okay, is that resulted in you chasing her?
Yes, ma'am.
Okay, do you understand now the mistake you made by chasing?
Oh, yes, ma'am, I understand.
And did you do this because of your past history
No,
with
ma'am.
her? With her?
Yeah, technically, yes. I didn't know what she was gonna do after that. So I really acted out of fear.
And you were afraid of her?
Yes, ma'am.
Okay, you know that we're here today for the judge to make a decision as to whether or not to allow you to be on probation or for you to go to jail.
Yes, ma'am.
Okay, is it fair to say, since you've been out of jail in February, you've completed all the classes that you told the judge about?
Yes, ma'am.
Are you currently involved in the batterers intervention and prevention program?
Yes, ma'am, I am.
Did you register for that as soon as you were released from jail?
Of course, yes, ma'am, I did.
Did it take you a while to become registered?
No, ma'am, it took me a couple days, like 2 or 3 days.
But the class didn't start for about a month.
Right, right.
So, right, so how many classes have you attended?
I attended 3 classes.
And how long do the classes last?
They're 6 months long.
And when do you go?
I go every Thursdays, 5:30 to 7:30.
Okay, and are you planning to complete these classes?
Yes, ma'am, I am.
Okay, you also said that you're also dealing with your mental health.
Correct,
Can
yes,
you-
ma'am.
Can you tell the judge what you're doing about your mental health issue?
I'm seeking a counselor. I'm seeking. They're gonna start putting me back on medication, ma'am.
Okay, let me stop you there. Where are you seeking help?
At Palo Alto Clinic.
Is that the Center for Healthcare Services?
Yes, ma'am, it is.
Okay, and you've already been there for an evaluation?
Yes, ma'am.
Okay, and you're supposed to, do you have another appointment coming up soon?
Yes, ma'am, on the 8th, no, on the 12th.
12th of May?
Yes, ma'am.
All right, so and as far as you're aware, they're gonna make a decision as to the medication that if you need medication?
Yes, ma'am.
And are you willing to take this medication if it's prescribed?
Yes, ma'am, because I do have some issues going on.
Okay, do you think part of the treatment's gonna be counseling?
Oh, yes, counseling, therapy, all that.
And are you willing to participate in all of that?
Yes, ma'am, I am willing.
And you've set all this up yourself?
Correct.
All right, have you ever been on probation before?
No, ma'am. Just juvenile.
Okay, what about adult probation for a theft?
No, ma'am.
Yes, you
Oh, yeah.
Your attorney says, yes, you have.
remember that? That was, I think it was in 2018, Matt. That's been a while. Let me see. Did you complete that probation?
Yes, ma'am.
Have you ever been on felony probation?
No, ma'am.
Do you feel like that you could comply with all the conditions of probation that the judge assesses?
Of course, yes, ma'am.
If the judge requires you to attend any kind of outpatient treatment for drugs, are you willing to do that?
Yes, ma'am, I am willing.
And I think, I believe you were placed on probation for theft in September of 2018. And you did complete that?
Yes, ma'am, I did.
Do you think you're a danger to the community, Raheem?
No, ma'am.
Will you ever engage in any kind of behavior like this again?
No, ma'am, I won't.
What have you learned from this incident, Raheem?
I learned that I don't need to react to every situation. I need to respond better. And I need to not react off my emotions. I need to learn how to call the authorities before taking matters in my own hand. And I need to learn how to walk away from the situation and be a grown man about it instead of acting like a child about it.
And as part of your history with Ashley Williams, has she made threats against you and your family previously?
Yes, ma'am, she has.
When was the last one?
Like around September 2022.
I thought there weren't any texted threats.
Objection to me.
That'll be sustained.
Is there anything else you'd like to tell the judge about why she should give you probation instead of sending you to the penitentiary?
Because 9 months I've been incarcerated. I really learned my lesson, ma'am. It opened my eye to be a better person, and two wrongs do not make a right. I have kids that I need to take care of, ma'am. I make an impact at my job. My GM is planning on making me assistant manager. So I really want to take that chance to run my own store one day. And I really just learned not to react in certain situations. I gotta come better as an adult. And just being around other inmates, seeing how their life is, that's not how I want my life to be. I feel like prison's not gonna make me no better or worse, or just,
You know, the judge is concerned about any kind of danger to the community. Do you feel like you would be a danger to the community in the future?
no, man.
All right, I'll pass the witness, Judge.
And there it is, the moment everything centers around. The defendant admits he got out of the car and fired a weapon. Even if fear played a role, that decision changes everything legally. Self-defense becomes much harder to argue when you chase someone and escalate the situation. This is exactly the kind of admission prosecutors rely on. So now the question becomes, was this fear or a reckless choice that crossed the line?
State.
Just, Mr. Asma. Quick question. You said after your car was hit, you said you didn't know what she was going to do,
Right.
but you did see her drive away and into a parking lot. Isn't that correct?
Yes, ma'am.
Okay. And you said you were afraid. Isn't that correct?
Yes, ma'am.
But your solution to that was to chase her.
I really just reacted the wrong way. I was just in shock. I was scared, you know what I'm saying? So I felt like I needed to take matters into my own hand, but now I realize I should have called the authorities. I should have made a police report. I should have weighed in on the crime scene.
And
So,
I appreciate that. But my
Yes,
question
ma'am.
was, you thought you were afraid, so you chased her with the gun. Isn't that correct?
yes, ma'am.
No further questions from me.
All right, any other questions?
Just briefly. And Mr. Asmore, did Ashley Williams run over you with a car?
Yes, ma'am, she has.
And did she call your work and threaten to shoot up your workplace?
Yes,
Judge
ma'am.
Winters.
All right, that'll be
Pass the
over.
witness. I have no further questions, Judge.
I have some questions.
Okay.
All right. From reading the stipulations, she's saying you brake checked her.
No, ma'am, I didn't break check her.
All right, so walk me through this. You're at the Valero
Yes, ma'am.
and you see her.
Correct.
And where were you? When you say you're at the Valero, were you inside the convenience store part? Were you at the gas pumps? What was going on?
I had parked my vehicle. I was pumping gas. I went inside the store. She had followed me. She went inside the store as well. I hurried up and walked out. I bought cigars. I was pumping my gas. We didn't exchange no words. She was at a pump on side of me. Everything was cool. I got into my car. I was still in my work uniform. I pulled out. She pulled up behind me. Next thing I know, she smashed me. My car does a whole 360 in the middle of Calabria Road. She takes off. That's when I did what I did now. I got out of my vehicle
And shot at her.
yes, ma'am.
And where did this shooting actually occur? Was this in the parking lot of CVS Pharmacy or somewhere else?
No, ma'am, it was on the corner of Calabria and Ingram.
Now, here's my other question, and this is not as for a question for you, it's the question of the parties. So did anybody have any CV footage of the accident? Because if this is happening outside the Valero, the cameras outside the Valero, if it's on Calabria, there are different convenience stores all along Calabria that can see what's happening towards the street area. Did anybody collect that?
To my knowledge, Your Honor, I believe there were a couple of attempts to collect surveillance, but none was able to secure. The surveillance showed from CVS showed a male running across the parking lot.
All right, but nobody did any thought to grab any information that would show or any evidence that would show the accident as it occurred?
I do think
And I'm saying accident. I don't know if it's an intentional or not because I haven't seen a video of it.
Judge, there's not even a crash report that was ever filed.
Okay.
but to answer the court's question, I do think there was attempts to get surveillance. Like I said, from CBS, it was non-inclusive. However, there were several witnesses that the cops did speak to at the scene.
But about this car crash. All right, because what I recall from stipulations is people are saying they believe there was a car crash, but nobody saw a car crash. And I don't know where they came up with, the witnesses came up with, they believe there was a car crash.
There was a witness that said there was a car crash, Judge. I think it's in the stipulations.
What I have, Your Honor, it sounds like
Mhm.
heard what sounded like a car crash.
Yes, but nobody saw it. So that's what I'm trying to figure out. Here's the thing, there are some missing pieces to this case. And let me tell you what the missing pieces are. The missing pieces are, one, were there previous terroristic threats made against you by the complainant, which, you know, you bring officers in here, people normally say they're supposed to believe the officer wrote the report. Then we have this witness testifying that outside of the terroristic threat to that his employer called in or whoever called in, he's testifying that there have been terroristic threats against his family members. Then we have this car crash. Do you all have the complainant?
No, Your Honor. And the state would just like the court to note that those reports that you have heard were 2 years before this incident.
All right, and I understand that, but if you think about it, we can go off the record. Let's for a moment assume that this is a female before me. And there's a male who 2 years before committed a terroristic threat, threatened the family, and then the female sees this male at Valero. Will we be making the same argument about it occurred 2 years ago?
Yeah.
So I just look at people as people. So I'm going to give you a choice here because there are some missing pieces to this case. These are your two choices. These are the only two choices you have with regards to sentencing in this case. So don't ask for anything else. Two choices. One, the state is asking that your punishment be assessed at a cap of 12 years in the prison. I'll give you two. Or I'm going to give you a deferred adjudication, and it'll be deferred adjudication for 10 years. You can step back and discuss that with your attorney and discuss it with whomever you need to discuss with, but those are your only two options, so don't come to me with a third option. You understand?
Yes, ma'am. I
All right.
understand.
All right, thank you. All right, we're back on the record in 2024 CR 008783. And you decided that you would prefer deferred adjudication, is that correct?
Yes, ma'am.
All right, the court is going to sentence you to 10 years deferred adjudication. There's a $1,500 fine. That will be probated. There's an affirmative finding of family violence. There should be no contact with the complainant. If the complainant reaches out and contacts you, I suggest you call the police. Your attorney will tell you what you need to do, or either call your probation officer to let them know. There's going to be 200 hours of community service restitution. I'm going to order parenting classes, and I believe he already has done those. And probation, that will be acceptable. And there'll be 100 hours deducted for parenting classes. And the remaining 100 hours will be deducted for once he completes the BIP. I'm going to order the BIPP course. I know he's done an anger management course, but I want the BIP. There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits 1 time per month. There's an affirmative finding of deadly weapon.
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And state,
Yes,
with regards to the GPS. What are your requests?
for full house arrest GPS.
I mean, he's been working. Hasn't he been working?
He's been working, Judge.
Sure, yes. Partial GPS.
All right. So what I'm going to do, I'm going to start you off with partial GPS for employment. If you do well on that, you can come back and within 3 months, then I'll do it for curfew. And then if you do well after that for 3 more months, then you'll be off GPS.
Okay, and for the court's information, he has been on partial GPS since February, I guess he was released from jail.
I understand. But so come back in 3 months. Then if there are no violations on GPS, we will do just a curfew. And then 3 more months, if there are no violations, then you'll be off.
Thank you, Your Honor.
You're welcome. So it'll be partial GPS for employment until further notice. And I'll just say until further notice, but you already have what the court's thoughts are on that, okay?
Yes, ma'am.
Thank you, Judge.
All right, thank you.
No
God
big
bless you,
excuse.
Judge.
All right, thank you. God bless you too.
In the end, the court delivers a balanced but serious outcome: 10 years of deferred adjudication instead of prison time. That means the defendant avoids immediate incarceration, but one mistake could send him straight to prison for years. With strict conditions, community service, and ongoing monitoring, this is not a free pass, it's a final opportunity. This case highlights how courts weigh fear, responsibility, and public safety all at once. So, what do you think? Did the judge make the right call? Or was this too lenient? If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.